Ever-tite Roofing Corporation versus Green is a case with a very similar set of facts to the case of Dickinson v. Dodds, which we discussed in the last video. But this case shows the result of the court's decision coming out in the opposite direction. So, to talk about the facts, let's go ahead and make our timeline here. So, what happens in this case is Mr. Green. So I'm going to do this in green. So green makes offer to Ever-tite. So Mr. Green has some roofing work that he needs done. He sends an offer to the Ever-tite Roofing Corporation, and in that offer, he provides for two methods by which the offer could be accepted. And that is either by sending written notice of acceptance or by performing the work. Uh, Ever-tite Roofing Corporation never sends a written notice of acceptance, but instead they just plan to show up and do the work and accept the contract in that manner. And so this makes Mr. Green's offer an offer for a unilateral contract. And recall that unilateral means that it is accepted by performance. So Mr. Green does not incur any liability under this contract until Ever-tite Roofing Corporation actually performs the contract. So Mr. Green, apparently expecting that Ever-tite was going to send a written notice of acceptance, doesn't hear back from Ever-tite Roofing Corporation, and so he ends up just hiring a different company to do his work. So Green contracts without Ever-tite. And you will recall from Dickinson v. Dodds that there was a similar sequence of events. So in Dickinson v. Dodds, you had Dodds make a contract offer to Dickinson, and you know Dodds gave Dickinson 2 days to answer. Dickinson ended up waiting, and after one day, Dodds ended up selling the property to a different person, and Dickinson found out about that and then scrambled to accept the contract. So this is sort of a similar situation where Mr. Green makes an offer to Ever-tite, and then while that offer is sort of in the ether, Green ends up contracting with a different company to perform the same work. And so in Dickinson v. Dodds, the court ended up ruling that this event, where Dodds had sold the property to another person, constituted a revocation of the offer, and basically killed the offer at this point, making it no longer available to accept. But this case, as I mentioned, ends up having a different result. So, what happens after Green contracts with a different company? Ever-tite ends up showing up. So Ever-tite prepares for work. So they load up their trucks, bring all of their materials out to the work site, and when Ever-tite arrives, they see that another company is doing the work. And at this point, Green tells Ever-tite, "Oh, sorry, we went with someone else," and he revokes the offer. And Ever-tite was a bit salty about this, that they hadn't been informed that Green was going with a different company, and so they end up suing Green for breach of contract. Okay. So if you'll recall from Dickinson v. Dodds, the analogous sequence of events. Here we had Dodds making an offer to Dickinson to sell his property, and then Dodds ended up selling his property to a different person. Dickinson found out about it, and then Dickinson tried to accept the offer, and that was when Dodds told him that the offer was no longer available, that he had waited too long. So in Dickinson v. Dodds, obviously Dodds wins, but in this case, Ever-tite Roofing Corporation wins. So let's find out why. So the contract offer that Green made to Ever-tite did not specify a deadline, did not give an expiration date for the offer. And so what the court does is it goes with that second option, that if the contract offer does not specify a date by which it must be accepted, then the offer remains open for a quote unquote reasonable time under the circumstances. And so what the court does is it says, since the offer didn't specify an expiration date, the court will infer that the offer remained open for a reasonable period of time, and it puts that reasonable period of time, and the court ends up saying that the reasonable period of time was sort of after Green revoked the offer. So the court inferred an expiration date that sort of superseded all of these events. This reasonable time to accept. So this is sort of the deadline that Ever-tite had to accept the offer. And then what the court does is it identifies this moment when Ever-tite packed up its equipment in the trucks, drove out to the work site. That this was the moment where the offer was accepted. Okay, so the key points are that we have the offer made here, and we have the offer accepted here, and then we have the revocation and the expiration. Okay, now notice that the contract offer is made here, and then it is accepted, and after it's accepted, that was when Green tried to revoke. And recall that the court had already decided that this was the reasonable period of time to accept the contract. Ever-tite was within that reasonable period of time, so they had accepted before the contract offer expired. Now, Green, of course, argued that this was not acceptance because, recall, his offer had said that the contract can only be accepted by performance, and Ever-tite hadn't performed the contract at this point. They had just showed up to the work site. And this brings us back to the London Bridge problem. So recall the London Bridge problem. The London Bridge problem said that if you have a contract, so let me draw a bridge here. So if you have a contract to walk across the London Bridge, so you walk across the London Bridge for a contract, a unilateral contract, You get a contract, a unilateral contract to walk across the London Bridge, and it is only performed by, or it is only accepted by performance. So in order to be entitled to the reward for this unilateral contract, you have to make it all the way to the end of the London Bridge. And there was this question, or this problem that came up, is that what if someone begins performance and gets right to the very end, and then the person that makes the offer tries to revoke? So what happens in that situation? And uh, the solution to this problem is that by beginning performance, and once performance begins, then the offer becomes irrevocable. So in other words, that once the person begins performing this unilateral contract, the person that made the offer can't just revoke once the person gets to the very end, but right before they cross the bridge. Instead, the rule for this is that once you begin performing, the person who made the offer has to give you a chance to complete performance. So once you begin performance, the offer becomes irrevocable. Now, it doesn't necessarily mean that the person that has begun performance is obligated to finish. They could still stop, and then there would be no contract. But if they start, then they have to be permitted to finish, and you can't just revoke the offer once the performance has begun. So that was the London Bridge problem, and you'll see that that is what happened in Ever-tite Roofing Corporation. Is that once Ever-tite loaded up its trucks, brought out the equipment, showed up to the work site, the court says that that's when they had started performance. And at that point, once they had started performance, uh, Green was no longer able to just revoke the offer. The offer was irrevocable, and so the court doesn't credit this revocation, and says that Ever-tite at this point had to have been allowed to complete the work. Now, one of the issues that comes up with looking at unilateral contracts in this way is, at what point do we credit preparation as the beginning of performance? So, you can imagine with the London Bridge problem, if the person starts training to walk across the London Bridge, maybe makes a few practice attempts, puts on his workout clothes and shows up to the starting line. The question becomes, has that person actually begun performing on the contract, or have they merely been preparing to perform? And that can be kind of a tricky issue that comes up. But you'll notice that the tenor of this case really emphasizes sort of Green's neglect to notify, Ever-tite Roofing Corporation about what he was doing, and failing to let them know that he had gone with a different company, and sort of inviting them to come out to the work site only to send them home. The court really is hard on him for doing that. And you'll notice that had Ever-tite Roofing Corporation been informed that Green had went with a different company, then the result of this case might be different. And so this is sort of the key fact that changes Ever-tite Roofing Corporation from Dickinson v. Dodd. was recall that Dickinson learned that Dodds had sold the property to a third party. Here, Ever-tite never learned that Green had hired a different company. And so they came out to the work site expecting that they were going to perform this contract, and that was when Green informed them. So again, the informing this person that you're contracting with about what your intentions are becomes really important. And like I said in the last video, had Dickinson not learned that Dodds had sold the property to a different person, that case might have turned out differently. And so the key takeaway from this case is that, if you do want to revoke a contract offer that you've made to someone, it's really important to let them know that that's what you're doing. Because if you wait, and especially if they end up, putting in a bunch of work to try to perform your contract offer, the offer at that point may become irrevocable.